Good afternoon, everybody, and welcome to episode 5 of Planning Shorts. My name is Matthew Fraser. I'm a barrister at Landmark Chambers, and I'm your host today. And we are going to be talking about the Business and Planning Bill, which is currently racing its way through Parliament, desperate to get royal assent before the summer recess on the 22nd of July. I have 4 excellent panelists who are going to help me navigate the bill, help you and me understand what on earth is going on with this bill. We're mainly going to be talking about the bill, but also looking at some other important COVID-related things like changes to the community infrastructure levy, and also get an update on where we are with remote decision-making and publicity and consultation issues in the COVID era. So before I introduce our panelists in true planning inquiry style, I have some housekeeping matters. The first is, please do remember that we have the chat and Q&A function. Secondly, we're going to try and respond to any questions or comments that you have during the webinar. And thirdly, if we don't manage to do so, then please feel free to contact any or all of us after the webinar. We'll be happy to talk about it. So if there's one thing that planners are famous for, it's acronyms. Whether it's convoluted legislative jargon or a creative residents action group, planners have an abundant imagination when it comes to acronyms. So when I ask each member of the panel to introduce themselves, I would like them please to give me their favorite acronym and why. Starting with you, Killian, and remember to unmute yourself, and please, for God's sake, explain where on earth you are.
Well, you know, Matthew, I've just thought I'm not going to say where I am. I'm going to let people during this try and guess where I am. I'll move the camera around somewhat to give people more of a clue. My name's Killian Garvey. I'm a barrister at King's Chambers. The acronym I'm going to pick is the NPPF, National Planning Policy Framework. I'm sure you all know that. The reason I picked that one is not because it's an original acronym. It's because the first time I ever appeared in the planning court, I used the acronym NPPF. And of course, the planning court was set up to be a specialist planning court for judges to hear planning cases. And I came before a judge who will remain nameless, but a judge in the specialist planning court. And I used the expression NPPF during my submissions, and the judge cut me off and said, Mr. Garvey, firstly, don't use acronyms in my court, and secondly, what is the NPPF? And I thought, perhaps this court is not as specialist as I thought. So NPPF, that's what I'm going for.
Thank you very much, Killian. How about you, Tora?
Thanks, Matthew. My name is Victoria, otherwise known as Tora Hutton, barrister at 39 Essex Chambers. Well, following on from Killian, I better pick the PPG, which technically apparently is not an acronym, it's an initialism, but I won't bore everyone with that. And I've picked it because when the PPG first was released in its beta version, I wrote an article about it. And I received, within about an hour of that article being published, a quite sort of shirty email from someone at MHCLG saying it's not the NPPG, as I called it, it's the PPG. And I was amused that there was a branding there, and I certainly wasn't with the message. Anyway, we all know now it's the PPG. Thanks.
Thanks very much, Tora. And I knew you were going to pick me up on my use of acronym inaccurately. Good. Well, I'll turn now to Ashley. And where on earth are you?
Hello. Well, I'm somewhere not anywhere near as exciting as Killian. I'm in suburban Surrey in a town called Esher. But it's lovely, and Elmbridge Borough Council do a lovely job in keeping it nice and tidy, and they're a lovely client. I'd love to choose an acronym which is fairly local to here, and it's POW. And POW stands for Protect Our Waverley. And I've chosen this for a number of reasons. Firstly, they were the people who brought the challenge to the Waverley local plan unsuccessfully, sadly for them. And so it's nice recent example of green belt and exceptional circumstances and inspectors' reasons in the Court of Appeal. Secondly, it's a great punchy acronym. You know, sadly the litigation didn't work out for them, but great acronym. And thirdly, it really does evoke a sort of vintage superhero comic element to it. So I think for all those reasons, it had all the ingredients for a good Residents Association campaign group acronym. So POW is my choice.
Thank you very much indeed, Ashley. And then finally, Thea.
Yeah, hello, Matthew. Just before I carry on with my chosen acronym, someone has asked if we can enable the chat function.
Oh, yeah.
You as the host have the option to do that, but if you don't, then people can just use the Q&A like a chat.
I'll see if I can. Hang on. Okay, I think hopefully I've now enabled it, but I'm so technologically inept.
Okay, so I'm Thea Osmund-Smith, Barrister at number 5 Chambers, and my chosen acronym is NIMBY. Now, of course, that stands for Not in My Backyard, and for those who don't know, this is a mythical creature. Much like Daily Mail readers, we know they exist, but no one will confess to being one. A favoured phrase of the NIMBY and the way to identify them is as follows. I don't object to all development. I support development in the right place, but this is the wrong place. Now, the wrong place is often in close proximity to the NIMBY's home, and that is how you can identify said mythical creature.
Thank you very much, Thea. So they are our 4 panelists for you this afternoon. So we're going to be talking about the bill, and I think it's fair to say that one of the biggest and most exciting changes in the bill is the much awaited legislative remedy to extend planning permissions, stop them from lapsing because of coronavirus, etc. And I think it's only fair to ask the author of a petition seeking this exact change, Killian Garvey, are you going to be seeking 100% credit for this legislative innovation?
No, I'm going to feign modesty and not take any credit for this. I think in reality, it was a pretty obvious and logical step that this was going to happen. So Scotland had already done it. Everyone needs it. It's in the interests of local authorities and developers that we don't see a huge number of planning permissions lapse. So
what's actually what's happening?
I'm deliberately
proposing.
So I'm deliberately moving, so you might see something in the background in a moment. I should say this is not a Zoom background. This is a real background. So the changes effectively extend planning permissions. For any planning permission that has already lapsed, between the dates of 23rd of March of this year and 28 days from when the business and planning bill becomes law, those permissions can be extended if you apply for an environmental approval. For any permission that lapses between 28 days from when this bill comes into law and the 31st of December, those permissions automatically get an extension, and that's until the 1st of April 2021. They don't need environmental approval. These environmental approvals, local authorities only have 28 days to determine them. They're free for developers, which is good news, and they apply in circumstances where it engages the habitat regulations. Also, in respect to outline planning permissions, we know that outline planning permissions are going to get an extension in terms of submitting reserved matters, where any reserved matter was due to be submitted between the 23rd of March this year and 31st of December. They get that extension to the 1st of April 2021.
Very good. Thank you very much. And I think also this might be a question for you. It's a sort of related issue that the bill is proposing, and it's all about construction working hours. Are you able to help us in terms of what is being proposed in the bill on that?
Yes, of course. So I should say these changes are changing the Town and Country Planning Act and bringing in temporary measures. So the extending planning permissions will become section 93A of the Town and Country Planning Act. The construction hours, they're bringing in a new section 74B of the Town and Country Planning Act. Section 74B brings in a deemed consent, a fast-track deemed consent route to extend construction hours. So effectively, anytime you've got construction hours secured by way of condition, and that can be either that the condition explicitly says it, or that the condition requires you to submit a construction environmental management plan. Anytime those construction hours, a developer wants to extend them, many of whom do wish to, because of social distancing means that you have staggered starting and finishing times, you can apply to a local planning authority. Local planning authority have 14 days to respond. If they don't do it, you get it automatically. It's deemed consent. And if local planning authorities, if they want to respond, they've got to do so within 14 days of the application. And there is guidance which effectively says to local authorities have a wide degree of latitude.
Jolly good. Okay, that's very helpful. So moving on from extending planning permissions and construction working hours, another big issue in the bill relates to planning appeal procedures. What's going on with that, Tora?
Thanks, Matthew. Well, before I start, let's just say we've had some very good guesses as to Killian's location. My favourite is Feltham Young Offenders. Killian, I think is a compliment to your skincare regime, maybe, I don't know. Anyway, appeal procedures. Yes, so the plan here is to, again, amend the Town and Country Planning Act and to add another section of it which would enable flexibility when choosing appeal procedures. So at the moment, obviously, we have written reps, hearings and inquiries, and you can't mix and match. So you're in one stream and you may be taken out of that stream and put into another. So an inspector may have a written reps appeal and say, actually, that's just happened to me the other day, so this isn't appropriate, we need an inquiry. And that can happen, but what you can't have at the moment is a sort of mixture of one or more procedures. And the statistics show, as we know, that appeal procedures matter. For years now, consistently, developers have been better off where they have an inquiry or a hearing as opposed to written reps. And there's a lot of theories as to why that is. My own view is that it's simply by giving time and space to the parties around a table that you're able to problem solve. So my feeling is that an inquiry or hearing, you're more likely to have the opportunity as a developer to offer up a condition or a 106 to deal with something which may be a showstopper were the appeal being dealt with on paper. However, and that's the positive side, the negative is, of course, inquiries in particular, and hearings also are longer and more costly. And so the government has taken the view that it would be useful to have some flexibility. And so where there are appeals which could be perhaps dealt with mainly by written reps, but there's a particular thorny issue which could deal with airing live, perhaps with cross-examination, then there is a proposal that inspectors, presumably it will be inspectors, deciding that these could be hybrid appeals. And in a way, it's part of the continuation of the Rosewell reforms, isn't it? Because we've already got the flexibility within an inquiry to deal with some matters by round table as opposed to cross-examination. And this seems like a continuation of that. But I think there are a number of issues up in the air here. First is procedural rules, because we have 3 separate statutory instruments at the moment. If you're in written reps, then you follow those rules, and if you're in inquiry, you follow those rules. And so there's going to have to be some sort of legislative amendment there to enable us to know how and the rules will apply. What input are parties going to have as to the procedure and which parts should be dealt with how? At what point will a decision be made as to whether this is going to be a hybrid appeal or not? Is there any right of challenge or review? And then I think a major issue which sticks out for me is that what if you have an appeal which on one issue is being dealt with by written reps, say landscape, and another issue, say heritage, is being dealt with orally by hearing or inquiry? What happens if at the hearing or inquiry an issue raises its head which is related to heritage, but actually it's a landscape issue and there's some crossover there? How is that then dealt with? And then I'm not in any way saying it's impossible, but I think these are issues that inspectors and parties are going to have to be live to. There is potential possibly for more procedural fairness challenges. And so then if that's the case, will it genuinely speed up appeals? We'll have to see.
And I guess the big question, Tora, that certainly in my mind, and I'm sure in a lot of others, is are these changes time limited to the current crisis, or can you see them having more longer lasting effects on the planning appeal system more generally?
No, I think that's the significant things, because a lot of these changes are temporary, like the ones Killian's just been talking about, which are going to sort of midway through 2021. This is a permanent change. And so that's the government's intention. I think the proof will be in the pudding. If it works well, then I think we will see it used widely and it will be here to stay. My feeling is it'll be very appeal specific as to whether this is a suitable option for inspectors. On the other hand, if there are successful procedural fairness challenges, hybrid procedures having been used, then that may dampen the enthusiasm for using them. So we'll just have to see, but at the moment they're here to stay.
Good. And so that's kind of where we are with the bill. And I thought it'd be useful to get a more general update about what's going on in terms of COVID-19 and remote decision making, because it's been in play now for some time, and I think we're now in a position to judge whether it's working, whether it's not working. And so I'd like to ask Ashley, can you just give us an update on where we are with remote decision making and issues like, and what sorts of issues planning committees are facing at the moment?
Yeah, certainly. Well, early on, it seems a long time ago, but only in the 4th of April, the local authorities, police and crime panels, coronavirus flexibility of local authority and police and crime panel meetings, England and Wales regulations came into force. And they effectively provide that meetings can be held remotely, telephone, video conferencing, webcast, etc., provided that certain criteria are met. And those are effectively that the members who are supposed to be participating can participate effectively by hearing everything that's said and being heard, and where appropriate, seeing and being seen. They effectively do it by tweaking some of the familiar statutory requirements of where a meeting is to take place. Can be now defined as multiple places, and a place can be online, it can be by live streaming, it can be by telephone and video conference, and a member can be present at that meeting taking place if they are able to participate and see and hear everything that's going on. So a fairly pragmatic way really of allowing things to continue whilst people weren't able to meet in person. I have to say, out of dedication to the cause, I logged into my local planning authority's Zoom planning committee meeting 2 weeks ago, and they were determining at that meeting a very large and controversial planning application, which was to replace a football stadium with a new 9,000 odd seater football stadium, subsidised by 1,000 odd homes in fairly high rise for Surrey anyway, towers, and to relocate some of the gym facilities onto a site in the Greenbelt. So a pretty controversial major meaty application. It was presented by an officer sharing the screen in the normal way, I suppose, as you would a PowerPoint presentation. It was easily accessed online. You simply click the link and it took you through as a member of the public to watch it. There were 2 public speakers. There was a very lengthy debate. There was a proposal for refusal, lots of nuanced issues about policy and previous inspectors' decisions and how all that was dealt with. Legal advice was given, and they came to an overall conclusion. So on that single anecdotal basis, it seemed to work pretty well. So they dealt with a very controversial thing by and large in sort of the same amount of time and as efficiently as they would have done in person.
What about consultation and publicity? Is all of that stuff working all right?
Yes, and I haven't gone off and done my own research in that respect, but I have to say that the government has passed new subordinate legislation to give effect to a social distancing world, and those are the Development Management Coronavirus Amendment Regulations, and they came into force on the 14th of May. And effectively, these provide that where legislation requires things to be available in hard copy and for physical inspection, that statutory requirements, so for example EIA, environmental statements, can be discharged now by those documents being available electronically. So it's a fairly pragmatic change. But the fairly interesting thing about those is that for consultation, it says that proportionate steps should be taken to draw matters to the attention of people likely to be interested, and that includes social media. So that is a truly innovative way of reaching people, and may also have some longer term beneficial effects, even though that and the previous one are both time limited in their effect. It may well mean that more people are reached by the planning system than would otherwise be, and more people are able to participate and have their say than otherwise would be. So there may well be some very small minor benefits that arise out of what's obviously been a very sad and troubling time for a lot of people. Thanks
very much, Ashley. While you've been speaking, I think it's fair to say that Killian can barely contain himself. He's been bouncing around the screen like a lunatic. And I think it's probably fair on the whole audience and on us, more to the point, for him to just, for God's sake, put us out of our misery in terms of wondering where on earth he is.
Well, I'm at Alton Towers, but I've seen some people trying to guess which ride I'm at, so that's the next challenge if people want to.
You want to just why on earth are you at Alton Towers?
That's the subject of next week's. I'll come up with a good reason that doesn't make me seem puerile by next week.
Okay, good. Well, just one more issue to deal with before we finish. Thea, the last thing I want to talk about is just a quick update in terms of what's happening with the community infrastructure levy. We know there are amendments that are coming into force in relation to the SIL regs later in the summer. There's going to be new guidance supporting this as well. What do the changes involve?
Okay, so here we have another catchily titled piece of legislation, the Community Infrastructure Levy Coronavirus Amendment England Regulations 2020, and they were laid on the 30th of June to come into force later on this summer. Now, what those do is they insert new regulations 72A to C into the SIL Regs 2010, and the purpose is to help ease the burden on smaller developers who may need more help as a result of the current health crisis. They apply to any SIL payment that has fallen or will fall due on or after the 21st of March 2020. So the regulations apply to developers with an annual turnover not exceeding 45 million, and it allows them to make a request to defer a SIL payment if certain conditions are met. So the first condition is that they have received a demand notice for a SIL payment. The second is that the SIL payment is to be paid before the 31st of July 2021. That's the material period for the purpose of the regs. And finally, that the company, the business, the developer is experiencing financial difficulties for reasons connected to the effects of coronavirus. So financial difficulties is defined within the amending regulations to include difficulties that would be likely to have an unacceptable impact on the economic viability of the business. So that indicates to me that the hardship has to be pretty serious for the deferral to be allowed. Now, the deferral request has to be submitted in writing by the developer, ideally 14 days before the SIL is due, but if not, then as soon as practicable after. And the collecting authority then has to consider the request as soon as practicable, and they can refuse it, but they have to do so within 40 days of receiving the request. Now, there's no prescribed format for the request or the information that's required, simply as I've said that it must be in writing. The authority can grant the deferral if it considers it is appropriate in all the circumstances. So therein, of course, is the murky area of judgment and discretion, which I'm sure will give us all boundless amounts of fun over the next year or so. Now, the deferral can be for no more than 6 months, and the developer will get a new demand notice. Obviously, as I've said, there's enormous discretion in this process. Now, the happy news is that while the authority is considering the deferral request, and even if they refuse the request, neither a surcharge nor interest is payable for late payments for 7 days after the date of the refusal. If late payment interest has accrued after the 21st of March, but before the date of the request, and that request is then granted, the developer can ask that the amount be credited against the SIL that is due under the revised demand notice, and that's called an interest request. Now, in relation to SIL charged by the Mayor, a deferral request may only be granted if the Mayor is of the view that it's appropriate for the payment to be deferred, and likewise in respect of late payment interest requests. Now, there's no appeal against an authority who refuses either a request to do with the SIL or the interest. Potentially, a developer could judicially review a decision, but there's a lot of discretion built into the regulations. And so I don't think that's necessarily going to be a very straightforward way of challenging such a decision. There is guidance that accompanies the regulations. That's already online and will come into force when the regulations come into force. It's helpful in terms of considering what sort of evidence is needed to show financial difficulty and how other linked businesses should be taken into account. So what the guidance does is it introduces the concept of sole enterprise and requires consideration of linked and partner businesses in the calculation of the 45 million annual turnover. Now, that's absolutely something that you would need to discuss with the company accountants if you were considering making a deferral request. It's not really one for the planners. Also helpful in the guidance, there's a really strong emphasis on early engagement between the authority and the applicant if questions arise as to any of the requirements for relief, or if the local planning authority aren't necessarily satisfied with what's been submitted.
And what other guidance is there for other applicants that you've been looking at?
Well, again, it's all online as part of the PPG, and in terms of other guidance, MHCLG have published guidance that was updated, I think last at the end of June, and that reminds local authorities that they can publish instalment policies, although that's not much used in areas where there isn't an existing policy, because any new policy that's published will only apply to development commencing after the date of publication. The guidance also reminds local planning authorities that they have a discretion when it comes to enforcement action and also late payment surcharges, and that they should be flexible and have regard to the government's clear intentions to ease the burden on developers when considering enforcement. However, as we know, there's no discretion to disapply late payment interest, which can be substantial in a lot of cases. And so again, I think that is perhaps of limited help to many people. So in summary, I'd say the changes are unlikely to ease the burden very much at all, but the regulations have the potential to provide significant flexibility for smaller businesses, and is likely to be a welcome break, I think, for any of those developers with turnover under 45 million.
Thanks very much, Thea. Well, most of the comments and Q&As that we've been having have largely been related to Killian's theme park antics, but there is a very, very good question that's been asked about whether council members are allowed to carry out site visits, and if so, is there a limit on numbers attending? Is this something you can help with, Ashley?
Yes, I'd be delighted to. I'm certainly not aware there's any preclusion on site visits going ahead. Even at their most restrictive, the general regulations, the regulations that created a criminal liability for leaving your house, allowed a derogation for travelling for work where it was necessary. But I think if you were a council conducting site visits, you'd need to think very carefully about your health and safety obligations to your staff. You'd need to think whether the site visit was truly necessary. If it was, whether you could make sure that people could remain 1 metre plus apart, I think is the most up-to-date guidance. And if not, I think you should be thinking about whether adequate pictures, videos could do the job. I would say that in all but the most complex of cases, probably a site visits at the moment perhaps ought not to be going ahead. But if it is necessary, certainly there's no legal preclusion from you doing so, but you may want to think a bit more widely about your health and safety duties to your staff and obviously members.
Thanks very much, Ashley. And thank you everybody for tuning in for the 5th episode of Planning Shorts. We're doing one more episode next week, the 21st of July 2020. We're then going to take a break over the summer and return in early September. And if he ever manages to escape from Alton Towers, the next week's host is Killian, and the topic will be heritage. Thank you very much indeed for tuning in, and hope to see you next week. Bye.
Thanks all. Bye.